Hello.
Hi.
Good morning. So the other day I talked about a 1538.5 and then I forgot to get back to you and let you know what it was. And I'm sure you all went home and looked it up, right? 1538.5 is in, anybody know what code? Almost always deals with criminal matters. So that's your hint. So what do you think? What code? Penal code. So 1538.5 of the Penal Code, and it basically, what it seeks to do is throw out or quash a search warrant that has been illegally obtained, or there's something that the defense can prove is wrong with the search warrant. So they're either requesting the return of the evidence that was seized and or throwing out the search warrant. Okay, this material has lots of exchange in it. And this is warm up. Okay. I am plaintiff counsel, Mr. Maynard.
I am the witness.
I'm Bert. I am defense counsel, Mr. Smith.
And I'm going to remind my readers, please make sure, I've heard from some people, we need to try the best we can to keep our chins up so our voices project out, and try not to fade off on the ends of your parts, so on and so forth. Okay. The court begins, and let's read this in 15s. This will be 200.
For the record, Ms. Sequist, why don't you come here? Have a seat. Have a seat on this side next to your counsel. Mr. Maynard, are you ready to go on this? I'm now calling the case of People versus Deborah Newton, also known as Sequist.
People call Officer Rustkamp.
I do.
Is there going to be a 1538.5 motion made?
Not at this time, Your Honor.
State your name for the record, please, and spell your last name for the court reporter.
Darren Rustkamp, R-U-S-K-A-M-P.
Who are you currently employed by?
City of Modesto.
And you're a police officer, is that correct?
That is correct.
On June 16th, 2014, at about 1 a.m., were you in the vicinity of Lakewood and East Orange in Modesto, Stanislaus County?
In the area, correct.
Why did you go there?
I was dispatched to an auto burglary, which had just been interrupted.
Well, I'll object. No foundation hearsay.
Overruled.
I'm sorry, I did not hear Mr. Smith's answer to the court's question. Is there going to be a 1538.5?
There was no 1538.5.
Okay, good. We'll make it quick then. When you got to the area, did you see?
I made an objection. There was no foundation.
That objection will be sustained.
When you got to the location, did you see anybody who's present in court?
Yes.
Who?
Seated next to the defendant, the public defender,
Could you identify that person?
wearing a multicolored blouse.
And what did you do once you saw the defendant at that location?
She was subsequently stopped.
And what happened next?
Objection, non-responsive.
The question was, what did you do?
I stopped her using my spotlight.
Okay, thank you.
And what did you do next?
After I approached her and the other subjects with her, she was subsequently searched.
And what did you?
Well, I'll object. I'll make a 1538.5 motion.
Oh,
Okay, then you may ask the original question you started to ask.
all right. Let's back up. Why did you go to that location?
While en route to the original dispatch call, I observed.
Well, I'll object. There's no foundation that there was. I'll also interpose a Harvey Madden objection.
No, it's not noticed.
I don't know of any requirement that it be noticed, Your Honor.
Well, you can't surprise them with it. This is the prelim time. If you're not prepared to go to prelim now, we won't go to prelim now.
I'm prepared, Your Honor.
Okay, fine.
And I'm making that objection.
Objections overruled.
Why did you go to?
I would request a hearing on that.
Overrule.
Why did you go to that location, officer?
I was originally dispatched to an auto burglary that was interrupted.
I object, hearsay.
Overruled.
And there's no foundation for it.
Why did you go to that location?
I was dispatched to an auto burglary which was interrupted.
And what did they tell you in that regard?
Objection, hearsay.
Overruled.
They gave a description of the alleged responsibles.
And do you have more than 5 years experience as a sworn peace officer?
Yes, I do.
And what did they tell you with regards to the auto burglary being interrupted, or was that it?
That was the information and also the description of the responsibles.
Did they give you any other detail? details with regards to how the auto burglary was being interrupted or who was doing it or what kind of car or anything like that?
No,
And the description of the responsibles, was that similar or dissimilar to anybody you saw when you arrived at that location?
Objection leading, no foundation as to what the description was.
Why don't you just ask what description was given and how did it relate to this officer?
What description did you receive?
the description was one of the persons was wearing shorts, and I believe they were red shorts, and I'm not sure of the color of the shirt. If I could refer to my report, maybe it would refer or better describe them.
If that will refresh your recollection.
My report doesn't indicate what the description was given of the call.
Okay, do you know whether or not any of the subjects you saw matched the description that was given?
Well, I object. There's no description
Just, Your
that
Honor.
he knows about to give.
Was the description given to you,
Yes, there was.
but your report does not reflect what that description was?
That's correct.
What's your next question?
Did, at the time you saw any of these people at that location, did you notice then whether or not their clothing description was similar or dissimilar to the description given to you over the radio or by your mobile data terminal?
Well, I object. We have no foundation as to what the description was.
That's not necessary.
Objection overruled.
The description was one person was wearing shorts, a dark colored shorts, or I believe red shorts, and was also wearing a shirt or a jacket type apparel. And the defendant did match wearing that type of apparel, shorts and a shirt.
What about the shirt matched to the description?
I believe I indicated that she was wearing a plaid shirt and
Does that, go ahead. I didn't mean to interrupt. Please continue.
I don't recall the description given for the shirt of the responsibles.
How many people did you see when you arrived at that location?
I originally saw the defendant at Sonoma, east of Orangeburg, which would be west of that location, so I didn't originally arrive at that location.
Hang on just a second. Okay, go ahead.
I had never actually arrived at the location of the interrupted burglary.
When you arrived at the corner of Lakewood and East Orangeburg, did you see the defendant?
I never got quite that far. It was at Sonoma and East Orangeburg.
When you got to Sonoma and East Orangeburg, did you see the defendant?
Yes, I did.
Was there anything in her immediate vicinity?
Yes, there was.
How many people were in her immediate vicinity?
2 other male subjects
What were the 3 of them doing when you first saw them?
riding a bicycle.
What did you do when you first saw these folks?
I immediately pulled over to talk with them.
Did you ask them or signal them in some fashion to stop writing?
I don't recall how I signaled them. If it was with a spotlight or not, I don't recall.
In some fashion, did you let them know that you'd like them to please stop writing?
Objection leading.
Strike that. Did they stop writing at some point?
I believe I pulled over to the opposite side of the road facing the oncoming traffic, and as I exited my patrol vehicle, they stopped even with my patrol vehicle.
Okay. How we doing? Let's see. Did you guys recently do a brief for that? Okay, somebody likes that our chins are lifted, so that's good.
It's easier to do when they're not stapled in there.
It is, because you can hold up
You can
paper.
go like that, yes.
Yeah, which reminds me, Beth, you don't have those black,
I looked.
Really?
I didn't look in my garage.
because I know
but-
at the time when you took them, I thought, oh, I should be buying those from her. And then
You
I,
remember me taking them?
yeah, I do, because they were good.
I don't remember. I must have given them to somebody else or something.
Okay, so here we go. Lots of exchange in here. We're pretty much staying at 200. Some of it's a little bit slower. So this is really good drill though. Let's start on page 10 up at the top, and that is Mr. Maynard. And again, let's stay same speed. 15s. Here we go. In some fashion, did you let them know that you'd like them to please stop writing?
Objection leading.
Strike that. Did you Did they stop writing at some point?
I believe I pulled over to the opposite side of the road facing the oncoming traffic, and as I exited my patrol vehicle, they stopped even with my patrol vehicle.
Did you ask them to stop, or did they stop on their own?
Well, I'll object, lack of foundation.
Overruled.
I believe they did stop on their own.
Okay.
Well, I object, there's no foundation for that.
Overruled.
Once they stopped on their own, what did you do?
I advised them why I was stopping them, why I would have stopped them.
And did you speak to the defendant, Ms. Newton, at that point in time?
Yes, I did.
Did she tell you anything about her criminal status at that point?
Objection, lack of Miranda.
I don't think we're in custody or there's any foundation that we need a Miranda yet.
Not yet. You may at some point.
Yeah, but we're a little premature.
Why don't you ask what question he asked?
Well, okay. After you advised these three people for the reason for the stop, did Ms. Newton tell you anything?
Your Honor, I'm going to object. This would be calling for double hearsay.
No, it wouldn't do that. I hadn't heard yet that he had advised them of the reason for the stop. You just assumed it's something I haven't heard yet.
What did you tell her and her friends as to why you would have stopped them if they hadn't stopped voluntarily?
They were riding a bicycle at night without a light, and also they had failed to stop for a stop sign.
What, if anything, did Ms. Newton state after that?
After being asked, she stated she was on probation.
Objection, double hearsay.
No, it's not double hearsay. Overruled.
Well, Your Honor, if I might be heard, usually a person is told that they're on probation. They're not the ones who actually impose it. So her reporting of what someone said to her is double hearsay.
No, overruled.
What specifically did she tell you with regards to her being on probation?
I asked if she was searchable. She said she was.
Did you then search her?
I did not.
Officer Bauman did? Did you watch him do it?
I did.
How much time elapsed from when she told you and Bauman she was searchable until she was searched by Bauman?
Less than 2 minutes, I would assume.
And what did you observe Bauman find during his search of her, if anything?
I observed him search a duffel bag which was attached to the handlebars of her bike, and I observed him to pull out a white coin purse.
And did he look in it?
Yes, he did.
Did he show you what was in it?
Not directly. I did observe what was in it, though.
How did you come to see what was in it?
He was approximately 3 feet from me and knelt down in front of the duffel bag, and I was standing watching the defendant and observed what he was doing.
Okay, and did you learn in some fashion what was inside this coin purse?
Yes, we did.
What?
It was a clear plastic container with a yellowish powdery
And
substance.
did you book that into evidence?
Yes, I did.
And did you ask the defendant any questions with regards to whose duffel it was?
Prior to the search, I did.
What did you ask her and what was her response?
I asked her if it did belong to her, and she stated that it did.
Did you make a phone call to the Department of Justice Crime Lab at my request earlier today?
I did.
And who did you speak to then?
Referring to
Your
the,
Honor, I'm going to object to him reading unless he needs to refresh his recollection.
Yeah, the question was, who did you speak to? Do you have to refresh your recollection?
I have to look to this to know. I don't know her personally.
You have to look at it to tell?
Now I do.
Okay, go ahead.
A Janae Lawson.
Did she tell you what her profession was?
Yes, she did.
What did she tell you?
She was a criminalist.
Did she tell you anything about her background, training, and experience with regard to the testing of controlled substances?
While looking at a copy of her resume, she verified the information I was reading to her, and she verified it back to me.
Did you read to her a copy of her resume?
She actually verified over the phone, and I followed along a copy of it.
Did you actually have a copy of the resume with you during this discussion?
Yes, I did.
And do you have that with you now?
I believe I returned that to you.
Would you check, please? Oh, never mind. Is this it?
That appears to be it.
I'd like to mark this as Exhibit 1. And did she read to you the contents of that resume, Exhibit 1, in its entirety?
She did.
Did she tell you whether or not it was true, accurate, and correct?
She did.
Did she tell you whether or not she tested any controlled substances?
She said she did.
Did you learn from her whether or not the controlled substance that you had tested was what you had seized from the defendant's possession, you or Bauman?
She said she did receive a sealed envelope from the Modesto Police Department with our case number on it.
Did she tell you whether or not she tested what you or Bauman took from her from the defendant?
She said that she did test that product.
And did she tell you what the results of the test were?
Positive for methamphetamine.
Did she tell you whether or not the tests she used on the methamphetamine that you and Bauman seized from the defendant were generally accepted in the scientific community for determining the presence of methamphetamine?
Yes, she did.
And how many items of methamphetamine did she tell you she tested?
2 items.
And what, with regards to the first item specifically, what did she find?
Positive for
And
methamphetamine.
did she weigh it?
Yes, she did.
What did she tell you the weight was?
I'd have to refer to my report.
If that will refresh your recollection, feel free.
It weighed 0.21 grams.
Did she test the other item that was submitted to her?
Yes, she did.
And what was the result of that test?
Positive for methamphetamine.
And what was the weight of that one?
0.12 grams.
And did you seize 2 items of suspected methamphetamine from the defendant this evening?
I believe one of them.
Objection, Your Honor. This evening, I have no notice of any action.
It was 1 in the morning. I'm not sure.
He said this evening, I thought.
What time was it, officer?
1 a.m.
Okay, objection sustained.
How many items did you seize from the defendant?
I believe 1 item.
And how was that item packaged?
It was in a hard, clear plastic wrapper with burnt edges to seal it.
Did you look inside the wrapper and see what you saw there?
Yes, I did.
And did you notice, what did you see in the wrapper?
I saw a white to yellowish powdery substance.
And what was the consistency of this substance?
From powdery to slightly moist.
Okay, and when you booked this item that you seized from this defendant into evidence, did you assign a number to it?
Yes, I did.
And what number did you assign to it?
That would be our case number of 9453115.
Did you assign an evidence number to it?
It's the same as the case number.
I'd like to show you a document. Did you discuss this document? I'll show it to counsel too. Did you discuss this document with Miss Lawson?
Yes, I did.
And she told you that there were 2 items that were tested, item 1 and item 2?
Objection, leading.
Overruled.
Try some M14s. Okay, continuing on. Is that correct?
Yes.
Now, were 2 items taken from the contact of the defendants on this evening or morning?
Objection, leading by word and gesture.
Overruled.
She said she did test 2 different things.
Were 2 items seized from the defendants at this occasion?
Objection, leading.
Overruled.
1 item was taken from this defendant and 1 item was taken from a separate defendant.
Which item was taken from this defendant?
It would be the item number 1.
Okay, and when you say the item number 1, what did the item number 1 weigh?
0.21 grams.
And Ms. Lawson told you she tested the item we are referring to as number 1 item, and that contained methamphetamine. Is that correct?
That's correct.
Objection, leading.
Overruled.
Thank you. No further questions.
Cross-examination.
What description did you have of somebody possibly involved in an auto burglary?
One of the subjects had on shorts and I don't recall the color of the shirt.
Okay, where is this auto burglary supposed to have occurred?
Near the area of Lakewood and East Orangeburg.
Okay, and was there any information as to the sex of the person?
I don't recall.
Any description as to the race of the individual?
I don't believe so.
Any mention of a bicycle?
I don't believe there was a mention of a bicycle.
Did you ask the defendant if you could search the duffel bag?
I believe that we did, yes.
And what was her response?
She acknowledged that it was okay.
And when the items of suspected methamphetamine was located, did you ask her about it?
After Miranda, I did.
And what did you ask her?
I asked her if it belonged to her.
What did she say?
Objection, hearsay.
Overruled.
He's got more than 5 years.
If it's not an admission, it's not admissible.
That's true. I take it this is not going to be an admission.
Doesn't he still have the 5 years?
What's that?
Doesn't he still have the 5 years?
I think it's self-serving hearsay. If there's a defense, I think I'm entitled to hear it from the defendant.
I think so too.
He can't talk to her.
Objection still sustained.
Well, did you ask her whose methamphetamine it was?
Same objection.
Objection sustained.
Might I cross-examine on what the officer did?
I've already sustained the objection to that question. Anything else you may ask?
Well, when you saw it, what did you think it might be?
As far as the contents?
Yes.
I believe it was probably methamphetamine.
Okay, was ownership of that item of any concern in your investigation?
Yes.
Did you ask anybody who owned it?
Objection, hearsay.
Yeah, objection sustained.
Officer, how many years experience do you have?
Objection asked and answered.
Objection
Do
sustained.
you have more than 5 years experience?
Same objection.
I still don't know how you get the self-serving stuff from the defendant. If you're trying to bring it, there's no other reason but to bring it in for its truth.
Doesn't this officer have more than?
It's just the defendant's statement.
What does that have to do?
Because it has to, if I may respond, it has to be otherwise admissible. It's not a blanket to get in all sorts of testimony. It's got to be admissible otherwise.
No.
You yourself objected that it was hearsay if it's not otherwise admissible.
No, we'll let the defendant testify about this if she wishes to.
Your Honor, are you saying that the prosecution has the advantages of this officer testifying to statements given to him because of his 5 years experience, but the defense doesn't have the advantage of this witness's experience in testifying to what somebody said to him?
This is not just a witness. This is the defendant. It doesn't come in for any other reason, and it's unreliable. When it's the statement of a defendant given to an officer and he's going to relate it to us, it has a certain unreliable aspect to it inherently, and it's inherently self-serving, and she should be cross-examined on them. Now, a lot of other times, other statements come in, and for a full explanation of those, we get into other stuff which is quite often inadmissible otherwise. But as to this,
Well, Your Honor, I'd move to strike all testimony by this officer of a hearsay statement.
objection overruled, it won't be stricken. Things told. You have to understand that things told by witnesses in a crime or things told by witnesses in a crime have a certain reliability factor to them. We would otherwise call them to testify, and they would, in all likelihood, testify to the same thing they told the cop. There is an inherently unreliable aspect to a defendant's self-serving statements.
What test did Janae Lawson perform on the controlled substance?
I'd have to refer to my report for the exact reading of the test.
Please do if that helps you.
Number one's called the Marquis, M-A-R-Q-U-I-S.
How did she do that?
It was not explained or asked.
What is a marquee test?
Objection irrelevant.
Yeah, objection sustained.
Did she tell you what the difference between a marquee test and a count test?
Same objection.
Overruled.
She did not.
Did she tell you what the difference was between a marquee test and a Duke test?
How many tests are we going to go through here?
There's also been no showing that these other tests were done.
Yeah, I think now I'll sustain the objection.
Well, what was the result of performing that test?
Objection vague.
The marquee test.
Withdraw.
The Marquis test, along with the other tests, tested positive for methamphetamine.
Well, that's the marquee test. What was the result of the performance of that test? What results did she get?
It was positive.
How did she know it was positive?
By the subsequent other tests she gave it.
Okay,
Well-
let's stop. We're going to slow it down and do some readback next. Okay? So we're going to read it now like in 17s. Okay.
Starting where?
We are going to start on page 24,
Oh, okay.
line 10. So this will be for readback. I will re-identify Mr. Maynor for the plaintiff.
I am the witness.
The court,
I'm Mr. Smith for defense.
Go ahead.
Begins with a question by Mr. Smith. For the record. So she didn't tell you what the result was?
She said that it was positive.
Why was it positive?
I don't have the answer to that.
She didn't tell you why it was positive?
I didn't ask her.
Why didn't you?
It's not one of my questions that I asked for Prop 115.
Okay, where did you get the questions from?
From the state,
From whom?
from the district attorney's office.
So Deputy District Attorney Maynor gave you a list of questions to ask.
That is correct.
Did she perform any other tests?
She said she did.
What other one did she perform?
A secondary amine, A-M-I-N-E, and a Scott's test, S-C-O-T-T-S.
Which one of those did she perform first?
Objection irrelevant.
sustained,
What's the difference between the two?
Objection irrelevant.
sustained,
What was the result of the first test?
Objection no foundation that he knows which one came first.
sustained,
Well, were the results different between the amine test and the Scott's test?
She did not advise that they were different.
And what result did she get?
A positive test for methamphetamine
How did she know it was positive?
through an instrumental test, which she also gave it.
What test was that?
The gas chromatograph, mass spectrometer.
Okay, what is that?
I don't know.
What did she do?
I don't know the process of that test.
How did she weigh the material?
I don't know the answer to that.
Did she use some sort of scale?
I don't know the answer to that.
Did she ever go to school?
She stated that she did, and also on her resume, it indicated she had.
What did she tell you?
Objection under 352, the resume speaks to that.
You're going to introduce that?
Yes, I'd move it into evidence right now.
I object. It's clearly hearsay.
I'm going to allow it to go under 352 as a summary of the officer's testimony, which would otherwise be very time-consuming, and the objection will be sustained.
Did you search the other individual that was with the defendant?
Objection irrelevant.
Why is that relevant to this case?
I believe something was located on that person.
Why is it relevant to this case?
I believe something was located.
Yes, but why is it relevant? Now that we know which item was located on this defendant, why is it relevant?
You've got two different subjects located at different locations. There can be an inference drawn that ownership is in one individual.
I don't have any inference I can draw like that. Objection sustained.
During your search of these two individuals, did you find any items that could be used to ingest a controlled substance?
Ingest, you mean orally?
Or any other way, taken to the body?
Through the mouth could be numerous ways.
Did you find anything?
I didn't find any spoons or forks or anything of that nature.
What about smoking paraphernalia?
Not on this defendant, no.
All right, on any of the individuals at the scene where the controlled substance was located?
Objection irrelevant.
Overruled.
I did locate on a separate defendant.
Who was that?
I would have to refer to my report for his name.
Please, if that will help you.
Brian Rialubin, Rialuben.
And what did you locate on him?
Specifically, I don't recall, but it was smoking paraphernalia and the other item of evidence.
What's smoking paraphernalia?
A smoking pipe.
Why do you term it paraphernalia?
It's objects of the crime,
What crime?
of the ingestion of the materials that were found.
I believe you said you stopped 3 individuals.
That's correct.
Who was the third individual?
I don't believe I have that in my report.
Would it help you to look at your report?
Sure.
Why don't you tell him where to look?
I think I'll object on the grounds of relevance. It doesn't really matter what the name is.
If you know where to look, he said he doesn't know where it is in his report. You either tell him where to look or I'm going to sustain the objection.
Stop. Okay. Read back. Page 24.
Thank you.
Ann, you want to start?
Yes, thank you. The question by
Actually, it was the other one, Smith.
The question by Mr. Smith. So she didn't tell you what the result was? She said that it was
Answer.
Answer. She said that it was positive. Question. Why was it positive? Answer. I don't have the answer to that question. She didn't tell you why it was positive. Answer. I didn't ask her. Question. Why didn't you answer? It's not one of my questions that I asked for probably 15. Question. Okay, where did you get your questions from? Answer. From the state. Question. From whom? Answer. From the district attorney's office. Question. So Deputy District Attorney Maynor gave you a list of questions to ask? Answer. That is correct. Question. Did she perform any other tests? Answer. She said she did. Question. What other ones did she perform? Answer. A secondary
Keep going, that's it.
amine, A-M-I-N-E,
Mm-hmm.
test,
And a
and a Scott test, S-C-O-T-T.
S.
S. Question, what one of those did he perform first?
Which one?
Which one of those? Mr. Maynor, objection, irrelevant. The court sustained. Mr. Smith, what's the difference between the two? Mr. Maynor, objection, irrelevant. Question, Mr. Smith, what is the result of the first test? Mr. Maynor, objection, no foundation that he knows is when he came first, the court sustained.
Okay, good. Something, what was that?
She missed the
Line
first
8.
court system.
Oh, the first court, okay, after Maynard objection irrelevant, the court came in and sustained. Okay, thank you. Whitney?
Question by Mr. Smith. Well, were the results different between the mean test,
The amine
test, and the Scott's test answer? She did not advise. Is that correct?
Yes?
Okay. Question, did she?
Oh, that they were different.
That they were different. Question, I just had, did she get?
And what result did she get?
What result did she get? Answer, a positive test for methamphetamine. Question, how did she know it was positive? Answer, through an instrumental test, which she also gave it. Question, what test was that? Answer, the something graph mass.
The gas chromograph.
Question,
Okay, wait. You left the rest out. Chromograph. Chromatograph mass spectrometer.
That's why I dropped it.
I know.
It wasn't worth it. Okay, question, okay, what is that?
Yeah.
Answer, I don't know anything to answer.
I don't know.
Okay, I don't know. Question, what did she do? Answer, I don't know. Question,
I don't know the process of the test. Question.
how did she weigh the material? Answer, I don't know the answer to that. Question, did she use some sort of scale? Answer, I don't know the answer to that. Question, did she ever go to school? Answer, she stated that she did, and also on her resume, it indicated that she had. Question, what did she, Mr. Maynard, objection?
Tell you.
Tell you, Mr. Maynard, objection. Something may speak to that.
Mr. Manager, under 352, the resume speaks to that. I'm going to stop you there. Thank you. Candy.
The court, you're going to introduce that, Mr. Maynard. Yes, I move it into evidence right now. Mr. Smith, I object. It's clearly hearsay. The court is going to allow it to go under 352 as it has.
As a summary.
As a summary of something's testimony.
The officer's testimony.
Officer's testimony, which would otherwise be very time consuming, and the objection will be sustained. Question, Mr. Smith?
Correct.
Did you
Search.
search the other individual that was with the defendant? Mr. Maynard, objection are irrelevant. The court, why is that relevant to this case? Mr. Smith, I believe something was located on the person. The court, why is it relevant to this case? Mr. Smith, I believe something was located. The court, yes, but why is it relevant now that we know which item was located on this defendant? Why is it relevant? Mr. Smith, you've got two defendants,
Two different.
two different subjects located at different locations. There, something
Can be and.
can be an inference drawn that ownership is in one individual. The court. Something like that objection.
I don't have any inference. I can draw like that. Objection.
Sustained. Mr. Maynard.
Guess again.
Mr. Smith.
Good
During
guess.
our search of these two individuals, did you find any
Items,
items that could be used to ingest a controlled substance? That was this question. Answer.
ingest,
Ingest, you mean orally? Question, or any other way something to the body,
take into.
take into the body. Answer, through the mouth could be
Could be numerous.
numerous ways.
Very good. Okay, I'm going to stop you there. Numerous ways, and then actually, he also says I, and then the question comes in, and pick it up there, please. Kristen.
Sure. Question, did you find anything? Answer, I didn't find any spoons or forks or anything of that nature. Question, a smoking paraphernalia?
What about?
What about smoking paraphernalia? Answer, not on this defendant, no. Question, all right. On any of the individuals that we've seen where the controlled substance was located, Mr. Maynard, objection is relevant. The court overruled. Answer, I did look on a separate defendant.
I did locate.
Locate on a separate defendant. Question by Mr. Smith, who was that? Answer, I would have to refer to my report for his name. Question, please, if that will help. Answer,
Help you.
help you. Answer, Brian Ralubeen, R-I-A-L-U-B-E-N. Question, and what did you look on him? Answer, specifically, I don't recall, but it was smoking paraphernalia and the other item of evidence. Question, what smoking paraphernalia? Answer, a smoking pipe. Question, why did you term it paraphernalia? Answer, it's objects of the crime. Question, what crime? Of the ingest of the materials. Ingestion of the materials that were found. Question, I believe you said you stopped 3 individuals. Answer, that's correct. Question, who was the 3rd individual? Answer, I don't have that in my report. Question, would it help you to look at your report? Answer, sure. The court, why you tell him where to look?
Why don't you?
Why don't you tell him where to look? Mr. Manner, I think I'll object on grounds of relevance. Just relevance or?
Correct.
Irrelevance. It did really matter what.
Doesn't?
Or it doesn't really matter what the name is of the court. If you know where to look, he said he doesn't know where it is in his report. You either tell him where to look or I'm going to sustain the objection.
Good. And I know you're all dying to know what a mean is. I thought it was funny that it was just as a separate word, but it is. A mean is any of a class of basic organic compounds derived from ammonia by replacement of hydrogen with one or more monovalent hydrocarbon radical.
Yes, so much better.
Oh, yeah.
Well, you do know it is a separate word. That's about all I learned from it.
Now I remember.
And it's probably involved with chemicals and drug testing terminology. You don't have to know what every word means. You just got to know where to find it if you need to. Okay, we're going to do a little bit of warm up from actually the only tape that you can use as a tape for the day, and then we will do a CSR. But first, we're going to do this one. Oh, this one. Take one, pass them down.
Oh, that's an extra. This is yours.
Oh, thank you. So we have some warm up. We're going to go up to page 9, and let's read it in 14s. Okay. This will be at 2:10. Let's identify. I am Mr. McCarthy for the plaintiff.
I am the witness.
I'm the court.
I am Mr. Diamond for the defense.
Starts with the court for the record. Let's go on the record then. This is the hearing before the Department of Alcoholic Beverage Control in the matter of the accusation against Thomas Chin, whose business is at 74 North Tustin Avenue in Anaheim. The file number for this case is 47297. The registration number is 90533. My name is Sunny Lowe. I am the administrative law judge assigned to hear this case. At the end of this hearing, I will submit my proposed decision to the director of the department. Will the parties please state your appearances, begin with the department?
Good afternoon, Your Honor. John McCarthy on behalf of the Department of Alcoholic Beverage Control.
Good afternoon.
Good afternoon, Roger Diamond representing the respondent.
Good afternoon. There's one packet of documents in my file which I'm now going to mark for identification. These documents are the accusation, the notice of hearing, the declaration of service by mail regarding the notice of hearing, the notice of defense, the statement to parties and respondents regarding discovery, and a declaration of service by mail dated July 28, 1995. All of these are documents marked as Exhibit 1, and Exhibit 1 is in evidence. Before we went on the record, the parties indicated that they will stipulate that the respondent has a 47 license since August 15, 1994, and that there is no record of a disciplinary action. Will the department so stipulate?
Yes, Your Honor.
Mr. Diamond?
Yes, Your Honor.
All right, any other preliminary matters that we need to take care of?
Yes, for the record, we are lodging an objection to the change in the law effective July 1, 1995 that replaced the Office of Administrative Procedure and the Administrative Law Judge with employees of the State Department of Alcoholic Beverage Control. We do object on the basis of the Due Process Clause of the federal and state constitutions on the ground that the independence of the hearing officer has been compromised by the change in legislation, so that no longer do we get an administrative law judge, but rather we get an employee of the department. So we do object for the record.
All right, your objection is overruled. This is really an issue that you need to address in an appellate court. In the meantime, are you ready to proceed, Mr. Diamond?
Yes,
And the department?
Yes, Your Honor.
Does the department wish?
I apologize. I have one additional technical objection, and I might be corrected by Mr. McCarthy, but it is my belief that the State Department of Alcoholic Beverage Control is behind in their publications, and that the rules and regulations of the ABC are not available in booklet form by purchase from the ABC and the law libraries do not necessarily contain updated versions of the code sections. So we object on the ground that the latest rules and regulations of the ABC are not generally available to the public as required by law.
Let me presume to address the issue because I just went over to the law library across the mall here, not mall, the square here, and I got me a copy of the code.
I have it too. My point, Your Honor, is that the ABC is supposed to have available in its own publication the rules and regulations. Unless things have changed recently, every time I've gone to the ABC to get the updated rules and regulations that they traditionally have published, they do not have those currently available. And Mr. McCarthy might correct me if I am wrong on that, but that's my position. And we can call in Mr. Rasmussen to establish that. But there is no current booklet available for sale that contains the current updated regulations.
Well, you can present evidence to that fact, Mr. Diamond.
Sure.
And argue that as a defense, I suppose.
But I do have, I suppose, to make sure that you and I are on the same page. I also did the same thing you did.
All right.
Photocopied the regulations, so we either have the same correct ones or the same incorrect ones. You have Article 22, I suppose?
No, I have Rule 143.
Yeah, Rule 143, which is underneath Article 22.
Right, Title 4 of the California Code of Regulations.
Yes.
I have that. Yes, I have that. All right. Mr. McCarthy, do you wish to make an opening statement?
No, Your Honor, I'll waive opening statement.
Please call your first witness.
Call Jamie Wilkes.
All right, Mr. Wilkes, come on up here.
I do.
Please have a seat. I'm going to ask all of those who will be testifying other than Mr. Chin to step outside. All right. All of the prospective witnesses other than Mr. Chin have left the room. Please state your name and occupation, Mr. Wilkes.
Jamie Wilkes, W-I-L-K-E-S. I'm a police officer for the city of Anaheim.
Go ahead, Mr. McCarthy.
Thank you, Your Honor. Mr. Wilkes, how long have you been employed as an Anaheim police officer?
I've been with the city of Anaheim since January of '82.
What was your assignment in February 1995?
I was assigned to the vice unit.
What's your assignment today?
I'm currently assigned to the street narcotics unit.
By the way, Your Honor, this is the witness that I indicated has an order to be back to juvenile court by 2 o'clock this afternoon.
I understand.
Mr. Wilkes, on February 2nd, 1995, did you have occasion to be present at an establishment called Mr. J's located at 74 Tustin Avenue, Anaheim, California?
Yes,
Did you go to Mr. J's on February 2nd, 1995 by yourself?
No, I did not.
Who did you go there with?
I believe I was there with Sergeant Walker.
Also with the Anaheim Police Department?
Yes,
And did the two of you go inside?
yes.
Where did you go, having entered the establishment on February 2nd, 1995?
Went to one of the freestanding tables and sat down.
And did you order something to drink?
Yes, I did. I don't recall what I ordered.
Okay. Was it an alcoholic beverage?
I'm sure it was.
Objection uncertain, lack of foundation, non-responsive.
Objection overruled. The witness has answered. He was certain it was an alcoholic beverage.
Okay. What did you see going on after you sat down at your table at the establishment?
I saw that there were females that were dancing on a raised stage that was basically in the center of the establishment. And they appeared to be dancing to 2 song sets. They would go up and dance to 2 songs and then leave the stage.
Was there a loudspeaker system in effect introducing the dancers by name?
Yes, they had a DJ that I assume was playing the music, and then he would also announce dancers.
Okay, we're gonna stop there, actually, because I'm gonna give it a 12-minute, which means, actually, I have to repeat some of that for your warm-up. Okay, so this is gonna be a 12-minute take. I'm gonna pause this and